this plea so I could go to the casino and spend your money. And that's not what occurred. What occurred was I had distinct marching orders from my client as to what to try and resolve this case at. The first marching orders were probation. The second set of marching orders were a year. The state wasn't willing to do it. Did my client know that he was looking at a possible life sentence? 100%. Did he know that a 2 to 5 could be less time than what he ended up getting, which was the 9 to 33? 100%. This is all we discussed.
Well, I guess that's what I'm trying to get at, because you keep going around in the circle.
It's not a circle. It's very specific.
Did you discuss when you went out in the hall during this break the state of the evidence?
Listen, it was a short amount of time. The whole idea, the whole
amount of time.
Listen,
How short was this amount of time?
I don't remember, but it was not a lunch break. It was a break. I mean, whatever the break was. 10,
Well, you
15.
tell me I wasn't there.
Well, I'll tell you what. Why don't we look at the tape, and then
Tell
we'll
you
know
what, why don't you
exactly.
tell me?
Because I don't remember.
There was no tape out in the hallway, was it?
No, but there was a tape on the recess.
Was there a tape in the hallway? No.
But
So let's go to this.
Actually,
Do you remember when that happened in the course of the trial?
no. I remember it happened well into the trial. We were all, this is the best word I can use. We were, I think Mr. Roger and Mr. Owens were feeling the effects of the trial, and I don't want to speak for them. I know that on our side, it was a constant battle with the judge, and I think that they lowered their initial plea offer to try and get some resolution. And that part's speculation, but I remember it was well into the trial. We were, and I really do say this out of respect, and I mean this, we were getting beat up by the judge, and we all were getting beat up by the judge left and right. And I went out and I said to OJ, is this possible? And he said no. And it's not like that was the end of the discussion, because we discussed it again after court. I mean, we were discussing it all the time.
Well, this is the first time now we've got that you've discussed this offer that was rejected.
No, that's not what I'm saying. What I
Well,
said
let me
was the
ask the
offer that
question.
was
Do you mind?
rejected was discussed in the hallway, but it's not like Mr. Simpson and I never discussed the consequences and the benefits of a plea.
Let us deal with the short period of time when you said that you conveyed this statement to Mr. Simpson. So let's just focus on that if we could.
Sure.
All right, you said that was a short period of time, but you don't know how long you spoke to him.
No, I said I didn't know how long the break was. I certainly spoke to him long enough to convey the offer, discussed the offer with him, and certainly discussed with him long enough where he said to me, try and get a year.
When you were out there discussing this in this short period of time, in this break, did you in fact go over the state of the evidence to that point with Mr. Simpson?
You'd have to define state of the evidence.
Did you talk to Mr. Simpson about the state of the evidence up to the time of this brief conversation in the hallway sometime during the trial?
I cannot answer that. I don't know. Because what you're doing is you want to know whether or not I gave him an opinion at that moment in time as to how I thought it was going, and I can't say whether I did or I didn't because I had You know, I mean, there wasn't a day that went by or a witness that went by that we didn't do an analysis of how we thought it went or how we thought it was going.
Well, once again, let's go back to that time and not the times before or times after, that time specifically.
But they're all the same.
Well, they're not all the same, are they? The
No,
time
they-
the trial
no,
is a
actually-
continuum, right?
Exactly. A
Actually,
trial
so
is a
let's leave it at there.
continuum.
Let's stop at that point. Did you tell Mr. Simpson that he was winning the trial?
Never.
Did you tell him he was losing the trial?
I had had a number of conversations.
On that time, that day, when you were talking to him about this offer, did you tell him that you thought the state of the evidence that you were winning or losing?
I would never, ever tell a client whether I felt we were winning or losing. I would say to a client, I just don't use that nomenclature for those words. I'd say it's either going okay
All right.
or, you know, we better really consider this.
Okay, well, let's use those words. Did you tell him while you were out there in this brief period of time, or the short period of time, that you thought the trial was going okay?
No, what I said to him was, you should really consider this. And
You-
he was, and that's what it was. It was the offer, consider it.
And then you went back in and rejected it.
I didn't reject it. I did what my client wanted me to do,
Well,
which was say, can we get it done for a year?
and did you then, after you went in and asked for it down to a year, did you go back and talk to Mr. Simpson about the fact that they had turned the year down and that you should consider the 2 years?
I certainly conveyed to Mr. Simpson that they turned down our county.
Okay, and did you then go back and say that I think you ought to consider the 2 years now that they've turned down our 1 year?
I said to Mr. Simpson throughout the rest of the afternoon that you need to weigh this very carefully.
Did you did you say that to Mr. Simpson before you went and spoke to, or right after you spoke to Mr. Owens or Mr. Rogers?
When I spoke to Mr. Owens and Mr. Rogers, and I conveyed that we might be able to get this done with a year, the next thing I said to Mr. Simpson was, they're not going to do it. Now, we started court, so at one of the other breaks, we discussed it further.
And was Mr. Grasso there in that one?
I don't know whether, I don't know. I mean, we were sitting at a table. So I was on the left, OJ was in the middle, Grasso was on the other side. Then we had CJ, Mr. Bryson, and the lawyer from Louisiana for some period of time, after Lucarini dropped out. I mean, that was the type of discussion that I probably would have waited till the evening to continue with him.
Well, then why were you telling us the lineup that you were sitting at the table? You didn't have that discussion.
Because
Okay, then let's take it to that evening. Okay?
Your Honor, might Mr. Patero let Mr. Galander answer the question before he asks the next one?
That would be nice.
What's that?
If you let him answer the
Mr.
question.
Sure.
Mr. Patero, you know, we're in the middle of the court day, so there are other things that the judge is ordering us to do to move the trial along. The preliminary discussion, however long it took, was 2 to 5, consider it, see if we could get it done in a year. Then we sat back and we went back into court, okay? At some point, before we all parted ways, I spoke to Mr. Simpson again about it. And he just was not going to do it.
When you spoke to him, did you tell him that you didn't think the thing was going good and that he was facing life imprisonment when you had this, what you call now, this longer discussion with him?
I said to him what I say to all my clients, which is...
No, I don't care what you say to all
Well, no,
your clients.
because
I care what you said here.
What I said, so what I said to him was, listen, you really need to consider this. Nobody ever knows what a jury is going to do. Nobody can ever really judge how things are going. You know, a lot of people dislike you. You know, this was after the If I Did It book, I mean, anybody that liked him after that was just, I just thought it was devastating for Mr. Simpson when he did that.
With all due respect, Mr.
Well-
Calandra, I have no idea what you're talking about.
Okay.
My
The
question had to
bottom
do with
line
plea
was, I certainly
negotiations.
conveyed to him that we didn't know what a jury was going to do, that there were a lot of people out there that didn't like him, that he really, really ought to consider the offer.
And where did you do that?
I either did it in the hall. I think I did it in the hall on the way out.
So when you're walking out the courtroom in the hall, you were discussing the plea negotiations again with him?
Yeah, I mean, we're alone and we're discussing issues.
Well, we're trying to talk about the plea negotiation, because you're aware that Mr. Simpson has testified that you in fact didn't make this offer to him.
I was not aware that Mr. Simpson testified to that. And, you know, it's just not an accurate statement.
Well, and so the point of the matter is, when we're trying to look at this, we want to know where you claim you were when you spoke to Mr. Simpson. Now, my understanding is, and let me just put it in context, when this case would break in the afternoon, those halls would be full of people.
Mr. Patera, first of all, there were definitely a lot of people. When OJ and I had something that we needed to discuss, we'd go off into a corner. Sometimes we'd use the room, one of the ante rooms. Sometimes we'd go out into the hallway.
All right, well, you said you were in the hallway.
And I believe we were.
Okay, now, how long did this conversation have after the court was over that you had with Mr. Simpson telling him that he ought to really consider taking this negotiation?
I didn't time it.
Well, was it a minute?
I didn't time it.
Well, then let's go into what it is. At that time, did you go through the state of the evidence and what you felt the state was?
I remember saying to Mr. Simpson, listen, there's an opportunity on the table. You need to consider this.
That was it?
In addition to what else I've already said,
Oh, but what you already said, you said it only took a short period of time. You told us this one in the hallway was where you then decided to talk to him about it. And now so you're telling us all you said was, geez, you ought to consider it?
no, Mr. Patera, you're
Okay.
mischaracterizing my words. I
I'm
didn't
trying-
walk out in the hallway and just out of the blue say, OJ, you ought to consider this. I said, listen, there's an opportunity. You really ought to think about it. I can go back to them. And again, he said to me, a year. I'm not going to prison.
He's not going to prison?
In his mind, he thought the year was at the Clark County Detention Center. He didn't, you'd have to be from Florida to understand, but he thought it would be local time as opposed to a longer period of sentence.
All right. So, in other words, what we then have is you saying that these conversations took place and no one else was there, was a party to it. All right? I just want to get that clear.
Listen, you know, Mr. Simpson,
Was anyone else there?
definitely not.
Okay. So then the answer is no one was there when you had these conversations that you claim you had.
First of all, I'm not claiming I had him. I had him.
I think that's one of the issues the judge has to decide, isn't it?
It's argumentative, Your Honor.
So
We'll disregard Mr. Simon.
Thank you.
Now, after that, did you go back to Mr. Roger or Mr. Owens?
And say what?
Concerning plea negotiations?
I don't think so. I may have, and again, I can't swear to this, I may have casually mentioned to Mr. Owens the next morning that OJ was still at a year.
So you
But
don't
again,
remember now?
I really don't.
Okay.
I mean, OJ was so steadfast in not wanting to do the 2 to 5 that I don't know if I mentioned something else to Chris or not.
Well, this morning when we started this whole process, you were asked the question by Mr. Simon concerning what, if you ever spoke to Mr. Simpson about the state of the evidence. And you said, I didn't tell him things were going good.
I'm going to object, Your Honor. I never asked Mr. Galander
Yeah,
that
I'm
question.
totally confused.
I asked him if he discussed a plea discussion. I didn't ask him if he discussed the state of the evidence.
That's true.
Okay. Mr. Simpson was, of course, relying upon you as an attorney, right?
Mr. Simpson definitely relied on my opinions as an attorney. That is correct.
And what I am asking you, did you tell Mr. Simpson that the evidence was good or bad, the way the trial was going?
This has been asked and answered, Your Honor. Mr. Galander has repeatedly said, I told Mr. Simpson that he ought to consider this.
Overall.
I told him he ought to consider it.
That wasn't the question.
What's your question?
What he's asking is, did you give him an analysis of where you thought things were with the evidence, and was the trial going well or poorly, or however you want to phrase it, but in a way that
I
conveyed to Mr.
Listen.
Simpson that you
Okay,
didn't think
so
the case
you
was so great, or
all right. So you need
or
some.
was great.
You need some background, and the background is that I would get up and do a witness, and you could see it on the tape. And OJ would lean over and whisper in my ear and tell me how he thought it went. Some witnesses, actually most witnesses, he would say to me things like, you know, Yale, you're great. You crucified him. You did this. You did that. I would always lean over and say something to him like, I don't even know if I could say this in court, but, you know,
Probably worse things have been said in here.
what I would say to him is things like, you know, don't let my smoke and mirrors fool you. This is serious stuff. And I meant that because sometimes, you know, clients do put a lot of faith in their lawyers, and they see lawyers do things, and, you know, a lot of it is smoke and mirrors. And, you know, this was a case that, you know, I thought that the evidence was overwhelming. And I conveyed that to OJ. I conveyed it to him all the time. I said to him, you know, this whole idea that you're going in and you're, you know, you had no intent to commit a crime, and then you got these thugs in the room and the guns, and, you know, I mean, he knew that I was not encouraging a favorable outcome. And that's really the best way I can put it. The other thing you need to know, Judge, is that in my career, I always leave these things up to clients. I never strong-arm clients, one way or the other. I lay it out as best as I can. I answer all their questions. OJ did not want to even consider more than a year, and I couldn't get Mr. Roger or Mr. Owens to lower where they were. And that's why the trial continued.
Thank you. Mr. John?
So you are telling us now that you told Mr. Simpson that the evidence was overwhelming against him?
I told him at various points during my representation that the whole defense of the guns, the thugs, the people pointing fingers at him, I just got robbed at gunpoint by O.J. Simpson, these were not good things. And he knew that.
I hate to do this to you, but I got to jump back.
You can jump anywhere you want, Mr. Patero.
Yeah, thank you.
Because it is what it is.
Yes, but you told us that this idea of the guns, that you described your cross-examination concerning the guns as stellar. And now you're telling us, after your stellar cross-examination, you turn to Mr. Simpson and say, Mr. Simpson, the evidence is overwhelming against you.
No, actually, in the middle of court, what I would have said to Mr. Simpson was, don't believe the smoke and mirrors or words to that effect. And, listen, I knew that OJ put a lot of faith in what I was doing in court. I mean, that's why he hired me to do this. I also know, based on what he would tell me after we would do a witness or a court day, of how he thought he was going. And I saw it as a very, very serious matter. And I conveyed that to Mr. Simpson. I discussed it with him. He could not understand why McClinton and Alexander got probation and they had the guns, and I couldn't get it for him, and I couldn't. And I got to tell you, I thought he was right. I mean, I think he should have been given a more lenient plea offer, but I couldn't get it done.
Well, from the time of this offer of the 2 to 5, or whatever you want to call it, when you then did you tell Mr. Simpson during the break that you first discussed with him, or in the hallway afterwards, that you thought the evidence as it existed at that time was overwhelming against him?
Probably not. Not at that particular moment.
Well, you understand one of the most important functions a defense attorney can do is the issue of plea negotiations, correct?
And you understand that this was a continuum. It's not, OJ and I, it's not like I got here at 8 every morning and left at 6 and said, bye-bye. I was with him a lot. We talked about these issues a lot. There is nothing that Mr. Roger or Mr. Owens would have conveyed to me that I would not have conveyed to Mr. Simpson. We were very, very close. So, if you want to go and say, Mr. Galanter, do you remember saying specific words at a particular time? I don't know how anybody could remember that. I do remember the day with the 2 to 5. And I remember conveying it. I remember telling him he should consider it. I remember him saying, get the year. I also remember talking to him at the end of the day about it.
You're aware of when the co-defendants were sentenced, of course, they weren't sentenced till after the trial.
I didn't get your question.
Well, no one had got probation at the time you're saying that OJ is saying they all got probation. They hadn't been sentenced yet.
They all had plea agreements.
They hadn't been sentenced yet, had they?
Mr. Patero, don't, listen. When you enter into one of these plea agreements where you become a cooperator and probation is an option and the district attorneys get to recommend something to the judge, it's probation. Now, yes, you're 100% correct that a judge could not do what a prosecutor says or not do what whatever the recommendation is, but it was clear that these guys were getting probation because my first meeting with Mr. Roger and Mr. Owens, that's all that we discussed, was the fact that the other guys were getting probation.
Did you put the plea offer in writing?
I was in the middle of court.
Wait,
And no,
no, wait a minute. You left court, remember, sometime, and you spent all these hours with Mr. Simpson. Well, let me just ask you this specifically.
listen,
Let me ask you this specifically. When you have an offer that you consider to be an offer on the table, that you believe is an offer that is in the best interest of your client, under the state of evidence, do you put it in writing?
it depends.
Do you put it in writing?
It depends.
Did you do it in this case?
No.
Now, you also advised Mr. Simpson concerning testimony, right?
Who's?
Him testifying.
Absolutely.
Okay. And you said that you told Mr. Simpson you didn't think he should testify.
My recommendation was that he not testify.
And you said that Mr. Simpson, when you told him not to testify,
I didn't tell him not to testify. I recommended that he not testify.
and now this is the same time you're recommending him not to testify, that you are telling him that the evidence is overwhelming against him. Right?
You need to define what time you're talking about.
Well, the evidence you told us just a few moments ago, that you always told them that you thought the evidence was overwhelming against him. Isn't that correct?
In terms of Simpson testifying,
No, if all you have to do is just listen to what I say, and then you can respond.
clearly I had expressed to Mr. Simpson that I thought the evidence against him was overwhelming. Clearly I had expressed to him that he should consider a plea offer, and clearly he told me that he only wanted to do a year.
We're talking
terms
about
of-
the advice of testifying now.
In terms of Mr. Simpson testifying or not testifying, it is clear that I recommended he not. The reason I recommended he not testify is because I didn't know, and I discussed this thoroughly with Simpson and with Gabe, I didn't know what additional testimony in regards to our defenses Mr. Simpson could offer that wasn't already in front of the jury. I told OJ that this is a very, very, very personal decision, and that the decision to testify or not is completely his. But remember, the whole idea of not opposing the tapes and letting the incident be played was part of OJ not testifying, and that discussion started in October. So it's not, this wasn't one of these, okay, Judge, we need 5 minutes to go out in the hall and talk to our clients, the way it normally works. This was a decision that was in the works for months, months, and months. Okay, Mr. Patero, ask your questions.
I am going to we're just going to take a break for about 10 minutes.
Here you go. Thank you, Judge.
First step back in session, please remain seated.
Okay. I wanted to continue with this on the advice not to testify. Mr. Grasso said that he advised Mr. Simpson to testify. Is that
Okay.
true?
I don't know.
He said, he's testified, that you told him not to talk to Mr. Simpson about testifying.
That would be inaccurate. Gabe sat right next to Mr. Simpson. He could talk to him about anything he wanted.
And is it your testimony that you never spoke or never heard Mr. Grasso communicate with Mr. Simpson that he thought he should testify?
During the trial?
Well, doesn't matter after, does it?
I never knew that Gabe and OJ had a discussion about OJ testifying,
Did you have a discussion with Mr. Grasso?
about whether or not OJ should testify?
Yes.
Yes.
And did you have that, and did Mr. Grasso tell you that he thought OJ should testify?
He never said that to me.
Did he, is it your testimony he told you that he shouldn't testify?
It's my testimony that when Gabe and I discussed it, he indicated to me that he didn't think that OJ testifying could add anything else to what was already in the record.
Now, you keep talking about the gun and the tape, or the tapes. Now, isn't it true that Mr. Simpson could say whether or not he saw a gun in the room?
Based on what I knew and what OJ had told me, if Mr. Simpson got on the witness stand, I didn't think it would be a good situation.
The question I had is, Mr. Simpson could say whether or not he saw a gun in the room.
Mr.
Correct.
Simpson certainly could have taken the witness stand and said anything he wanted to say.
Now, we talked about intent. Mr. Simpson could talk about his intent of going there, couldn't he?
His intent was all over the record. I mean, ad nauseum, he stated, I mean, that was the whole point of admitting the tapes. He stated ad nauseum that his intent was only to get his property back, that he thought it was his property, that he had no intention of taking anybody else's property. So clearly that was already in the record.
Mr. Simpson could have testified that to the jury, correct?
Sure. Like I said, he could have said anything he wanted to
Well,
the
let's
jury.
talk about his intent. He could have looked at the jury, couldn't he? The jury could have looked at his demeanor, correct?
Right. Mr. Patero, I'm not sure I know where we're going here.
I
advised him.
It doesn't
listen,
matter. All
I
you have to do is
advised him.
answer the questions.
I advised him that I didn't think he should testify. I
Well,
also told him that this was a very, very personal decision.
Let's go to
Judge
demeanor.
Glass went over with him the query, proffer, canvas, whatever word you want to use, and said the exact same thing. I mean, if this was a decision for him to make, and clearly my recommendation to him was that he not testify.
All right, let me go back to my question.
Sure.
Okay, listen carefully. Isn't it true that Mr. Simpson could have testified and looked at the jury and told them what his intent was?
As I have said, now
that
for
a
the
yes?
third time, Mr. Simpson could have gotten on the stand and said anything he wanted to the jury.
Is that a yes then?
I'm
This is
sorry.
argumentative and asked and answered, Your Honor.
Well, the problem, Mr. Simon, is that it is not answered. It has been asked several times, but it has not yet been answered. But I take it, Mr. Blanchard, from your response that the answer would be yes.
Yeah, I mean, we can go through 100 things that he could have done, but he didn't want to do it. he didn't want to testify. And it's not only that he didn't want to testify at the time of the trial, he didn't want to testify well before the trial. That was one of the crucial things that went into the tapes decision. But go ahead, ask all your questions.
Thank you. So, what we have here is Mr. Simpson could have testified, right? But he
Of course.
relied upon you and you told him not to testify.
I never told him not to testify. I
told him
told
he's
him
got
that
it.
my recommendation, you keep mischaracterizing what I said. What I said to him was, listen, it's my recommendation that you not testify. I don't think you could add anything to this, but it's a very personal choice and it's your decision.
You understand that the demeanor of a witness on the stand is a thing that the jury takes into account,
Absolutely.
and that the jury would have been able to listen to Mr. Simpson testify.
Yes.
Okay. And Mr. Simpson could have testified concerning his intent.
Yes.
Okay. Now, you've told us that the reason that you had were so hot on the tapes coming in is because the tapes didn't show any gun. Right?
What I testified to this morning was that the word gun wasn't mentioned in the tapes. That's
All right.
correct.
Now, isn't it true? I mean, you're an experienced attorney with hundreds of trials.
You keep saying that.
Well, you say it. That's the only reason I did. Okay. You had the detective on the stand, right? And you could have asked him one question concerning the gun. Isn't it true that a gun was not mentioned any time while Mr. Simpson was in the hotel room? Isn't that correct?
That's correct.
And that detective, who we will assume would tell the truth, would say, yes, that's true.
Okay.
Is that correct?
It's correct. There are a lot of assumptions, but yeah,
Well,
based
there's
on
only one assumption, is one, you said that the detective, you could ask him that question,
absolutely.
and if he's telling the truth, which we assume he would say, no, there was no mention of the gun.
Based on what his interpretation of the tape was, yes, that's correct.
And his interpretation of the tape is what was contained on the tape as well as what's in the transcript.
Correct.
And in the transcript, there was no mention of a gun.
That is correct.
So the transcript that was prepared by the police had no mention of a gun.
That's correct.
So at that point, if the point you're trying to make is there's no gun, there's no reason to let the rest of the tape in, is there?
All right,
Is there?
You need to go back.
I will
What's
go
on
back. You have two discrete incidences with this tape. You have when Mr. Simpson is in the room, and you have when Mr. Simpson is not in the room.
Correct.
It doesn't matter what happens after Mr. Simpson is not in the room concerning whether there was a gun on the tape, mentioned on the tape when Mr. Simpson was in the room.
Correct.
Okay? So you would have been able to establish very easily by the state's own witness, the investigating detective, and say, detective, isn't it true that there was no mention of a gun while Mr. Simpson was in the room? And he would probably have said yes. Well, let's say he says, I don't know. And then you could have said, detective, let me show you the transcript that you prepared. And would you please find in your transcript where that is? You could have done that, right? Done that hundreds of times.
Sure.
All right? So the point is that letting in the back part of the tape, the time when Mr. Simpson was not in the room, had absolutely nothing to do with what you say is the reason you let it in. That is, there was no mention of the gun. Right?
All right. Now I'm really confused. You went from what I could have asked the lead detective
Right.
to why I let the tape in, which we probably testified about an hour and a half on already. So are you asking me whether or not I asked the detective?
Let me ask it this way, so
Okay.
you're not confused. I want you to be confused. You told us that the reason you left, you let in the part of the tape where Mr. Simpson wasn't in the room was because you wanted in it being shown that there was no mention of the gun. Right?
Correct.
Okay. And we know from what you just told us that the tape portion when Mr. Simpson is in the room has no mention of the gun.
Correct.
Therefore, at that time concerning a gun in the room, there is no reason to put in the rest of the tape, is there?
Other
Mr.
than,
Mazzaro,
Huh?
can you hold for a second?
Sure. All I care about. Now, isn't it true that you, on the testimony, it said that you're not aware of Mr. Grasso ever discussing with Mr. Simpson of whether or not to testify?
yeah, I was not aware of that till this proceeding.
Now, what's that? Now, I do want to go into another area with you, and that is the conflict. A motion was filed by the state that they felt that you had a potential conflict of interest, correct?
Correct.
And you understand under your reading of the rules of professional conduct that an individual who has a conflict cannot represent a client in that action.
Correct.
And you understand that 3.7 specifically deals with the issue of a lawyer as a witness.
I mean, I'll take your word for it.
Now, you told us this morning that you had a conversation with Mr. Simpson on September 12th at dinner.
Correct.
And isn't it true that you had a number of telephone calls with Mr. Simpson prior to September 13th?
Yeah, I would say that in the 10 years that I've represented Mr. Simpson, there were a number of phone calls.
But let us look at the phone calls and the conversation that you had with Mr. Simpson. Could I, I'll over here a minute.
Mr. Mazzaro, why did you just ask the clerk?
Are you familiar with this document?
I've seen it.
Well, you saw it in the truck, correct?
Like I said, I've seen it.
Okay, and it talks about the time period before the robbery, right?
Correct.
And it lists in there a number of people.
Correct.
All right? And down at the bottom, it has Mr. Simpson's daughter.
Okay.
And I'm sorry, Jude, that was trial exhibit 78.
Thank you.
Okay. Yeah, I got it.
And when there is, in fact, a person who is relevant to this case whose name isn't on this exhibit 78, is that correct? You,
Are you asking me or are you telling me?
both.
Okay, well, I can only answer
She's asking
questions.
you.
I'm sorry, I'm asking.
I didn't prepare the exhibit. I mean, that was the exhibit that Detective Caldwell testified about. He said in the exhibit that not all calls were reflected on the exhibit. He specifically told people in the courtroom that calls between me and Mr. Simpson were not on that exhibit. And I'm not sure I'm getting your question, but
Well, what we had was this motion, correct?
That's not the phone call exhibit, is that the one you wanted?
What's that?
That is not the phone call exhibit. There's an exhibit, there's actually 2 poster boards that have all the phone calls, although good luck reading it. It's the small
This is the one I thought it was that we were given. Oh, I took the wrong one?
That's the one that was on session.
Yeah.
No, give me the one that has the little squares on it.
As in like-
Little squares. And there's another one.
This is the only one I've seen.
No, that's it.
I'm sorry,
That's it.
that's it?
I thought that was good. It's the other one first.
No, Ms. Palmer, this is from September 11th through the 13th.
Okay.
This is a different date.
Got it.
This is the 13th.
Okay, I just, okay.
Okay. Now, in the motion to disqualify you, it was stated that there were numerous telephone calls between you and Mr. Simpson. Is that correct?
I'd have to see it.
God bless you.
Okay.
You have that?
I'm looking at it. I have it.
Okay, take a look at it.
I have.
Oh, you want me at the back?
Okay.
This was a motion filed by the state for a motion to disclose conflict of interest, correct?
Correct.
Under 3.7 of the Rules of Professional Conduct.
Correct.
All right. And in this motion, it says defendant's cell phone records reflect numerous telephone conversations between defendant's cell phone and Mr. Blanchard's cell phone, correct?
Correct.
And then you filed a response well, Mr. Grasso filed a response saying that you wouldn't be listed as a witness.
Correct. They, Look,
Okay,
it's
fine.
not, I need the exhibit to answer the question. The state, one stated that out of an abundance of caution, that they were afraid they were going to get snookered. So they didn't want me to be a witness, they wanted me to declare whether I was a witness or I wasn't a witness.
So that's a snooker motion?
Is that what you said?
No, it was a motion to, out of an abundance of caution, to let it be known whether I was or I wasn't.
And one of the reasons was because of the telephone record showing that you had communications with Mr. Simpson before this incident, correct?
Well, there were two reasons stated in the motion. One of the reasons stated in the motion was because I was allegedly staying at the Palms Hotel. I was not staying at the Palms Hotel.
Did
Period.
I ask you about the Palms Hotel?
Well, but I'm giving that as part of my answer because that's part of the motion. The second thing they stated was that there were phone calls between me and Simpson.
Yes.
Okay, there were.
Well, there is no telephone calls reflected here, are there, between you and Mr. Simpson?
Again, Mr. Patero,
Are there?
I didn't prepare, it's not my exhibit. I didn't.
This was an exhibit you had during the trial, right?
I didn't prepare the exhibit.
Mr. Picard, I will take judicial notice that
Okay.
that Mr. Glanter is not on
Okay,
state
good.
since
The,
87.
the key is that Detective Caldwell testified as to why, but
I know, just for the phone.
Now, you then stood up and told the court that the telephone records would show that you had a phone call after the incident. Isn't that correct?
we did have a phone call after the incident.
You didn't mention that you had any phone calls before then, did you?
The court already knew that we had phone calls before the incident. That's what Detective Caldwell's testimony was all about.
Well, there's only one problem.
Yeah, go ahead, tell me.
Yet, that the representation you made was 7 months before Detective Caldwell testified. So obviously Detective Caldwell wasn't testifying to that,
In the
was he?
plea colloquy with the court as regards to this exhibit, it was clearly discussed that the state had phone records, that the state knew of my phone calls between me and Mr. Simpson. And I don't remember exactly, but I think it was at the court's suggestion or Caldwell's suggestion that they be excised.
Caldwell, the detective, is
Yeah,
saying
show
to be
me,
excised?
show me, I think it's 4962. Do you have that, Judge? Can I see that? It's in Ms. Palm's, it's her bait stamp number.
I know, but if it's a trial transcript, they don't have.
Anyway, the bottom line is that Caldwell is testifying how the chart was made, it was inaccurate, he didn't put all the phone calls, and not only with me, for whatever reason, he chose to put some phone calls on there and not other calls, and then he specifically said, I did not put phone calls on there between Galanter and Simpson.
Now, let's look at page
49, I think it's 4962, Judge.
000, 8, 40, and 41, and ask you to read it to yourself.
Okay.
Wait,
Well, I needed to answer your
Well, give it to
question.
me first, I'll give it back to you.
Okay.
Now, isn't it true that you told Judge Glass, and this is approximately 7 months before the trial started, Judge, I tell you, as an officer of the court, not only am I not testifying. Now, when you said that, did you discuss that with Mr. Simpson?
Yes.
Do you have a waiver of the conflict with Mr. Simpson?
There was no conflict.
Did you discuss it with him?
Yes. Listen, there was a rumor.
When? Did you discuss it with him?
I don't remember when.
Well, here's the thing, you didn't have Mr. Simpson present at that hearing, did you?
No.
Mr. Simpson wasn't there when your conflict came up, was it?
No.
Okay.
That's,
Nor did you discuss-
that's an inaccurate statement. That's when the hearing on the conflict came up. That's not when the conflict came up.
Mr. Simpson was not present when you made the statements to the court that I tell you as an officer, I'm not testifying.
He was not at that hearing.
Right.
The March 7th
And
motions
the
hearing, he
hearing
definitely was
was-
not there.
It was a hearing on whether you had a conflict.
It was a hearing on a lot of things. Part of it was whether I would be a witness or not.
Whether you had a conflict.
Correct.
Okay. And you then told the judge, I wasn't there, I had nothing to do with it.
Hey, you're cherry picking those words.
Mr. Delanta,
You're,
These
Mr.
are-
Patero,
isn't it
that's
true-
why I said I needed the transcript,
Mr.
because I knew
Delanta-
that's what you were going to do.
isn't it
So
true?
can I have the page?
Gentlemen,
Judge, I would like the page.
okay, but you need to stop arguing, and you need to talk one at a time,
Okay.
because it will make a very bad record when you go talk.
And I'd like the record to
Isn't
be
it-
crystal, and I'm requesting a copy of the page.
Did I just give it to you and have you read it?
I need it in front of me.
Okay.
Mr. Carroll, what page are you looking at again?
841, to be page 79 of the transcript.
So ask your question and then give me the transcript and I'll answer it. So you're holding on to it like it's a prized possession.
Do you have another copy of the transcript? I just don't, I only have the transcript, I have the paper copy at home and I have this electronically here, so I do not have another copy of the transcript, but
I only have them with this.
I know, I'm just asking, you don't, Mr. Chairman, nobody has another copy of the transcript? I might.
It's okay, I remember what it is. Judge Glass wants to know whether or not I'm going to be a witness. I say no. Then there's some discussion about whether I was at the Palms Hotel. I was not at the Palms Hotel. And then I go on to say that it is accurate that there are phone calls between me and Simpson. As a matter of fact, I think I say.
Show me
it's-
where you told the judge that you had phone calls with Simpson before this incident.
Okay, so here's what I say at line 12.
I'm asking you, just tell me where in that transcript it says that you told Judge Glass that you had had these phone calls before the incident.
I say to her, now David and Chris somehow either subpoenaed my phone records or Mr. Simpson's phone records. I don't know. And their allegation that Mr. Simpson and I spoke via my cell phone and his cell phone after this took place is 100% correct.
All right, now,
And
that's
above
fine.
that, I say, I will tell you as an officer of the court, I didn't stay at the Palms Hotel. I wasn't there. And I didn't stay at the Palms Hotel, and I wasn't there.
Well, let me ask the question again.
Sure.
Show me where it says that you told Judge Glass that you had had these telephone calls before this incident with Mr. Simpson. You've told us, you've read it, that you said you had a phone call after. I'm asking you to show me where you told her you had something before.
Let's see what the question was.
I could save us a lot of time and tell you you didn't.
Well, but it's in response to an answer. I mean, it's in response to a question. If you're intimating that Judge Glass would have said to me, with me knowing that David and Chris had our phone records, Yale, did you have a conversation with Mr. Simpson before this incident? And I would have said, no, that's preposterous.
Well,
Again, because if you look at the phone records, Simpson and I always talk by cell phone.
Mr. Pinero, I read it, it's not in there, if you could just move on.
it's not in there, is it?
It wasn't asked.
Well, I guess now we have to go back to what you said on direct now, once we brought up that you in fact had spoken to Mr. Simpson about this incident the night before.
You're talking about the night of the 12th at the
Yes.
restaurant?
Yes.
Correct.
Okay, and when we talked then about candor with the tribunal under 3.3, you never mentioned to Judge Glass, Judge, yes, I had dinner with Mr. Simpson the night before this, and we discussed him retrieving his property. You didn't tell her that, did you?
First of all, I was never asked whether or not I had dinner with Simpson the night before. And whatever I discussed with Simpson the night before would have been confidential. That's why I didn't want to disclose it this morning.
Well, it wasn't confidential because you understand the rules of confidentiality, don't you?
Well, the rules of confidentiality say that if there are other people present, it's not confidential.
Are there other people present?
Well, there were certainly other people at the table, but I don't think anybody else heard what we were talking about.
Well, you don't know that, do you?
I don't. But
Well, you know that-
here's what I do know. I do know that Mr. Simpson was leaning in very close to me, and I was leaning in very close to Mr. Simpson. I also know that my words to Mr. Simpson were not being received well. So I certainly considered it an attorney-client conversation.
Well, the point of the matter is that when we were talking, when the court was talking in March about telephone conversations or conversations that you had with Mr. Simpson, what you said was, I found out about this afterwards from the telephone call.
I did.
And you have told us today now that in fact, you had had dinner the night before with Mr. Simpson.
I did.
And Mr. Simpson has testified that he asked you about this, retrieving his property. And you're aware that Mr. Stewart, in his report to the police, mentioned that you were there with Mr. Simpson and Mr. Simpson had asked you about it. But when Judge Glass is dealing with a conflict with you, Mr. Valanta, you, rather being candid with the tribunal, you just happen not to mention this conversation.
You're mixing apples and oranges.
Let me ask you this. If, in fact, you had had the conversation with Mr. Simpson the night before, that would have been something that the judge would like to have known when we are dealing with whether you have a conflict. Don't you think that?
Okay.
Don't you think that?
Again, what OJ told me.
Do you think that?
No.
Okay? So you don't believe that the fact that you met with Mr. Simpson at a dinner and discussed retrieval of his property the night before was something that the judge should know?
No.
As a matter of fact, the basis of the motion was because the state believed, and you know this, the state believed that you in fact had conversations with Mr. Simpson, and that those conversations may have been reflected in the telephone calls, the cell phones, correct?
First of all, the telephone calls...
Is that correct?
No, it's not correct. The night of the 12th, one of the phone calls was a minute, and I think the other phone call was 2 minutes. So the whole idea that during those phone calls, OJ would have discussed this elaborate plan with me was absurd. Those phone calls are we meeting for dinner and why are you late? What OJ told me at the dinner had nothing to do with the incident that ultimately resolved. OJ never told me he was going to the Palace Station. He never told me he was going to tell guys to bring guns. He never told me he was going to go into a hotel room. And he certainly never told me he was going to take property back by force.
Mr. Galanter, Mr. Simpson has testified that he had had not only conversations with you the night before, but he also had telephone conversations where the retrieval of his property and Mr. Riccio was discussed.
When?
From what is it? From August 16th through September 12th.
Okay.
And if you want to look here, you can count, we have a marked the number of calls that you had.
Okay. As I have testified, you can certainly look at my phone records, and on any given week, in any given month, for 10 years, see phone calls between Mr. Simpson and I.
Mr. Simpson, 10 years ago, didn't ask you about this retrieval of his property. He started asking you a few weeks before he met you in Las Vegas, didn't he?
That is incorrect.
As a matter of fact, Mr. Simpson asked you about this incident, or about the retrieval of his property. And you said that you discussed it with him at dinner. And you said there were other people there.
Okay. Are we discussing the August phone calls, or are we discussing the dinner conversation? Or are we discussing both?
And when the judge asked you about the conflict, all you said was, I found out about this by a telephone call after the fact.
That's correct.
And you didn't tell the judge that you had in fact had dinner with him the night before about this incident.
No.
Okay. Now, you then entered into a stipulation for the jury stating that you in fact had no telephone calls.
No, that's not what the stipulation
Okay.
was.
Judge 4987, 92308 trial transcript. You were one of the parties in this trial, correct?
You need to start on page 4962 and read it from there.
It's obvious that you, contrary to what you had said earlier, you've gone through this record pretty clear that you can cite us to specific dates, haven't you?
Mr. Simon told me that there was an issue about this exhibit and that you were going to accuse me of not having candor with the court. I went back and looked at the record because, having done this myself, I know how lawyers cherry pick things, and it's clear what Detective Caldwell did. And it's also clear that what you're asserting occurred never occurred.
All right.
You're making, no, because I resent that. You're making it seem like Judge Glass did not know that there were phone calls between me and Simpson, and Judge Glass did not know that Caldwell intentionally left things off the chart. And that's just not, that belies the record.
Well, let me read the record to you.
Which page?
Mr. Galanter, I appreciate that you're frustrated because you feel like Mr. Pitaro is attacking your reputation as a lawyer. I understand that.
That's not what's bothering me. I
want-
think what he's doing is he's cherry picking, and
Okay,
you need to
but,
read the entire portion.
That's something that lawyers do, I understand that. I will say again to you, I have read the whole record, I will take everything into context, I understand, and I sort of anticipate Mr. Pitaro is going to ask questions that favor his side, Mr. Simon is going to do the same thing, and I will look at the whole thing in context when I'm making a decision. So please, if you could just answer his questions, then Mr. Simon will be able to clear up anything that he thinks needs to be cleared up.
But from my point of view, Judge, if I may, it's not about the sides. It's about what's accurate and what's not accurate.
Okay, I understand, Mr.
That's why I didn't want to
Mr.
be
Blanchard,
called as a state's witness or a defense witness.
You are a witness in the case, so I need you to be the witness.
You got it.
Okay.
Okay, I was gonna ask you this some other time, but seeing you brought it up. You didn't want to be called as the state's witness. That's what you just told the judge, correct?
I didn't want to be, I just wanted to be a witness. I didn't want anybody to have to go through the processes of subpoenaing an out-of-state witness. And when I was first contacted, I told actually Mr. Owens that if anybody requested me to testify, they wouldn't have to go through the hoops and hurdles that I would appear.
All right, so let's go to this, because you were saying you're a reluctant witness being here. That's what you told us this morning, right?
Correct.
So, and as a reluctant witness being here, you paid your own way.
Correct.
Okay, you didn't have the state pay your way. As a reluctant witness, you decided that you would pay your own way to Las Vegas, correct?
Yeah, I could afford it.
Well, probably with some of the money from Mr. Simpson.
But I mean, I'm not sure I understand your point.
You don't have to understand it, I just have to understand it. And what I understand is that in truth and in fact, you paid your own way here, and you weren't subpoenaed, were you?
No, I don't have a subpoena.
Yeah, let me see that subpoena. You want to tell us when you got the subpoena?
I got it this morning.
Where did you fly in from?
Fort Lauderdale.
Fort Lauderdale. So when you're flying from Fort Lauderdale to Las Vegas, you didn't have a subpoena.
Correct.
You hadn't been subpoenaed by the state.
What I was told by
You
the...
hadn't been subpoenaed by the state.
Okay. I had not received a subpoena yet,
Hold on,
but
Mr. Blanchard. How is this relevant to anything?
Because they wanted to bring up what a reluctant witness he is and how he's just so sorry that he has to be here. And he's paid his own way, and it shows what he is really here on to try to protect his reputation.
no, actually, none of what you just said is correct. The reason I'm a reluctant witness, Mr. Pitaro, is because I knew that based on either Mr. Simon's questions or somebody on the defense team's questions, I was going to have to disclose confidential communications. And I would never, I mean, that is just a very uncomfortable position for me to be in.
Let's have a motion where the state filed saying,
Mr. Pitaro, I'm very familiar with that motion.
Okay.
I understand what's going on here. I have a whole picture of it if we can move on to something
okay,
else.
I will.
Thank you.
Now, let's go back to where we started before your reluctance. And that is, I want to read to you from the court record the following on page 4987, 92308, trial transcript. And it starts on line 14. Mr. Owens, listen carefully. So
Oh, I know what it says.
Mr. Owens, and I think before we leave these particular phone calls, Mr. Galanter and I have a stipulation. I think it was sought out to save time. The court, okay. I had asked, this is Mr. Owens, I had asked Mr. Caldwell if he recalled the examination of the records to me, if there were any phone calls from Mr. Simmons to E.L. Galanter prior to the incident at the Palace Station. And I think we're agreeing. That's you and Mr. Owens. And I think we're agreeing that there were no phone calls back and forth between them prior to that. Then the court says, after Mr. Owens makes that statement. Now let me just
before, you don't stop up and say, that's not correct, jury. What you then do is you sit there, and then the court says, all right.
So for the jury's information, the parties have stipulated that before the incident, there were no phone calls that were seen on the phone record between Mr. Galanta and Mr. Simpson. Now, isn't it correct? That is what Mr. Owens said, and that is what the judge informed the jury of.
I would say that the entire 10 pages speak for themselves.
Why don't you just talk
And-
about the part we just read of the stipulation?
Because you can't read that out of context with what occurs earlier.
You know that a stipulation by the court of the part, to the jury of the parties, makes that fact binding on the jury. Isn't that correct?
There was a discussion.
Isn't that correct?
There was a discussion, but you're making...
Is that
this-
correct?
Of course it's correct.
Okay, and isn't it true that what was said, no cherry picking, no nothing, this is what was said. And that is the court. So for the jury's information, the parties have stipulated that before the incident, there were no phone calls that were seen on the phone records between Mr. Blanchard and Mr. Simpson. And that's what the court said, wasn't it?
That's what the court
Yeah,
said.
and that
on
was the stipulation that the court gave the jury, wasn't it?
That's what the court said
Yes.
on that page. And if you go, 3 or 4 pages before that, which would have been, 45 seconds? There's a whole discussion on how Caldwell constructed the chart, why he did what he did, and the phone calls he left out. And he intentionally left out phone calls between me and Mr. Simpson. I mean, I don't know how you have the judge, the prosecutor, the defense lawyer, the detective, all discussing this in open court, and then you're making it seem like something improper occurred.
The Caldwell court, or testimony that you're talking about, has to do with Exhibit 75,
No,
which
the-
was the date of September 13th.
No, the Caldwell testimony that I'm talking about is the fact that everybody knew what my phone records were. It was fully disclosed to the court. And for whatever reason, Mr. Owens and the detective decided to prepare these exhibits however they wanted them prepared. The judge, and again, I don't remember exactly, but for some reason, the judge thought it would be confusing and, it was fine with me. I mean, there's certainly nothing surreptitious. You've got the prosecutor, you got the cop, they're the ones that had the records, and we're discussing it with the judge.
Mr. Galante, it wasn't that it was just fine with you. You stipulated to it.
Actually, I don't say a word. Mr. Owens says we've stipulated to it. If you're going to be accurate, be accurate. There's nothing in the transcript where I even utter a word. But I'm telling you, my recollection is that this whole discussion starts a few pages before that, and not like it wasn't disclosed.
The point is that when you said that you didn't, when the judge, you didn't stipulate, all right, for the jury's information, the parties had stipulated. Did you stand up and say, Judge, I didn't
No,
stipulate to
what
this?
I said was, if you're going to be accurate, I don't say anything, and I also said that you can't read that in a vacuum.
Would you please read again there, did the judge say to the jury that you and the state have stipulated you had no phone calls with Mr. Simpson?
I'm not going to do that unless the
Familiar
court...
with what the stipulation says. So if we can move on.
And as a matter of fact, that stipulation, well, there was no mention, as we've said, about you having dinner with Mr. Simpson the night before.
Correct.
And as a matter of fact, there is no discovery
that you saw that has any mention of you having dinner with Mr. Simpson?
I considered my discussion with Mr. Simpson to be confidential.
Well, you know, that you're having a confident, you're an attorney of how many years?
Mr. Patel.
How many years?
Listen,
How many
my
years?
client tells me
How many years?
since 1982.
Okay, and so you're telling me that you believe that you have a confidential communication when you're sitting around a dinner table in a hotel with a bunch of other people?
Is that your testimony? I guess it is.
Are you testifying for me? May I?
Now, and on this conflict, as we've said, Mr. Simpson wasn't present.
We have no waiver of any privilege with Mr. Simpson. Correct?
There was nothing to waive. There was no conflict.
You realize, of course, that Mr. Simpson has a valid defense if he relies upon the advice of counsel.
Okay.
Isn't that correct?
An individual would have a valid advice of counsel defense if a number of things occur. The first thing that has to occur is that the person seeking the advice has to disclose all the pertinent and material facts. The second thing that would have to occur is that the individual would have to follow the lawyer's advice to the letter. So ask me what your question is about the advice of counsel defense.
Well, the advice of counsel is that
That was up to Mr. Simpson to decide in consultation with a conflict-free attorney. He didn't have a conversation with him the night before about this incident.
Okay.
That was never disclosed to the prosecutor or the judge.
First of
By
all,
you.
First of
Wasn't.
all, there was no conflict, and I resent the fact that you even intimate that there was. That's number one. Number two, what I told Simpson was to call the police. He balked. Then I said, call security. None of that occurred. There was no advice of counsel because there was nothing. It was him making a statement, me giving a response, him doing what he wanted.
Excuse me, Your Honor. I would like to object at this point to Mr. Patero's line of questioning on the basis that it's based on a false premise. Mr. Galanter testified early this morning, long time ago, that he did not advise Mr. Simpson that it was okay to get the property back. There would only be a reliance on advice of counsel if Mr. Galanter had advised him that it was okay. He has specifically denied doing that.
Listen, the whole idea, Mr. Patero,
I don't-
that mi-
Wait a second, it's my turn.
You're
Wait a
right.
second. I am going to overrule the objection. Mr. Pataro, if you would ask another question, please.
Now, you're aware that Mr. Simpson has said that he explained what was going to happen concerning the retrieval of his property, aren't you?
he never said it to me.
You're aware because Mr. Simon told you before you came here to testify that that's what he had said, right?
That never occurred either.
Isn't it true that you said to Mr. Simpson that he could get his own property back?
Never.
Isn't it true that throughout the trial, you argued that Mr. Simpson had the right to get his own property back?
I did.
Isn't it true that you raised that, Mr. Grasso raised that argument at the writ hearing? Well, you guys raised it at the preliminary hearing and you lost. Correct?
We raised, all right, we need to back up.
No, we don't. You need to answer the question.
I don't understand your question, so
Did
you
you
need to
raise
rephrase
in
it.
front of the Justice of the Peace, Bonaventure, that Mr. Simpson was within his rights to get his own property back?
Yes.
Did you also, and you lost?
Judge Bonaventure ruled against us.
That means you
That's-
lost.
That's correct.
Yeah. Then you raised it in a writ in front of Judge Glass,
And we definitely lost.
and you lost. And then you tried to raise it in the trial.
I didn't try to raise it in the trial, I did raise it in the trial.
So then, you then tried to raise it or did raise it at the trial, but that wasn't a correct statement of the law, was it?
It was, well, I'm not sure I totally agree with
Now,
that.
did you get a jury
Clearly-
instruction?
clearly-
Did you get a jury instruction from the court that Mr. Simpson could retrieve his own property?
We begged, and that's the only word I can use, Judge Glass for a theory of defense instruction, which was ultimately denied.
So the answer is no. You didn't get it.
Right, we didn't get it, but not for lack of trying.
Well, you see, here is the thing. You then, as I understand it, made a number of public statements concerning this case. And one of them was, he can't be found guilty of taking his own property.
Well, but here in Nevada, he can be and he was.
Now, the point is, apparently, you never figured that out between losing it at the preliminary hearing, losing at the writ, not getting instruction, losing at district court, and then losing it at the Supreme Court. Now, isn't it strange to you that the thing that you raised all through the trial, in court, and to the press, is exactly the same thing that Mr. Simpson said that you told him about the night before?
Objection, Your Honor. There's a big difference between raising a legal theory in open court and advising a client that he can go do something. They're just different. Mr. Galaner has testified that he advised Mr. Simpson not to do it. Mr. Simpson went ahead and did it anyway. When they got to court, Mr. Galaner tried to use that as a defense unsuccessfully. Two different things.
Okay, Mr. Simon, that sounds like argument instead of an objection. Thank you.
As a matter of fact, Mr. Galante, you made a statement to the court at 6083 that if Mr. Simpson would have run it by his myriad of lawyers, you know, obviously the advice would have been, you're out of your mind, don't do it.
Okay,
Isn't
and
that correct? That's what you told the court.
my advice.
Isn't that, you told the court that?
Yeah, I mean, the transcript
Okay.
speaks for himself.
Yes, it does. And what it says is, if Mr. Simpson had run it by any of his myriad of lawyers. Isn't that what you said?
Yeah.
Okay, and yet, when you said that, you didn't tell the court or anyone else that you, as one of his myriad of lawyers, had been asked about it the night before this incident happened. Did
Mr.
you?
Patero,
Did you?
your premise,
Did
the
you?
premise of your question, sir,
Did you?
is wrong.
Did
Mr.
you?
Simpson never told me the night before that he was going to go into the Palace Station with a bunch of thugs, that he asked to bring guns, keep people in a room, and forcibly take his property back. And the insinuation that I would have blessed it or anybody else with a license to practice law would have blessed it is insane.
Not only is it not insane, or maybe it is insane, but you said it.
Mr. Pataro,
No,
Mr.
that's
Simpson,
not
him something
correct.
specific, I would prefer that you not approach the
Okay,
witness.
I think you said I could.
You can if you're showing him
Okay.
something, you don't need to ask, but I.
6098.
Don't need you just giving him a space for no reason.
If you know Mr. Simpson had run it by any of his myriad of lawyers. There was no mention when you said that you had he had run it before you the night before.
This
He
has been
didn't
asked
run it
and
by me
answered,
the
Your
night
Honor.
before.
Insisting.
Mr. Galanta, in addition to Mr. Simpson talking with you the night before about retrieving his property, let me just get this clear. What you are saying is that Mr. Simpson in fact did talk to you about retrieving his property.
No, as I testified to this morning, Mr. Simpson mentioned the word sting, told me that some of his stolen property may be in Las Vegas, and I said to him, call the police. He came back with the police aren't going to do anything. I said, you got to call security. Then he said, it's probably not going to happen. And then when we were walking out, he said, this isn't going to happen, don't worry about it.
Now, Mr. Galanter, let me go back. So Mr. Simpson did talk to you the night before about retrieving his property. Now, what you're trying to do is say that what Mr. Simpson said that you told him is different than what he's
This has
testified.
been asked and
No,
answered several times.
Sustained.
Now, speaking of these tapes and conflicts, you were mentioned throughout many of these transcripts, weren't you?
You'd have to show me. I know that my name came up.
And when your name came up, did you discuss with Mr. Simpson the fact that your name had come up?
Well, when my name came up, it was by Mr. Simpson.
When you spoke with Mr. Simpson about your name coming up in these tapes, did you speak with Mr. Simpson about the fact that with your name coming up, that you were a potential witness?
When the whole issue of the conflict came up, I had sat down with OJ and said to OJ, listen, they think somehow I was involved. He laughed. He thought it was absurd. Absurd. Because, again, there was an allegation that I was at the Palms Hotel. I wasn't at the Palms Hotel. There was another allegation that I could have been in a white something or other, and OJ told me he didn't even remember there being a white car there. I wasn't there. I didn't have anything to do with it, and I didn't know it. Can you imagine Simpson wanting me to defend him with me blessing this plan? Can you also imagine him never telling anybody about this until all the appeals were done and lost? I mean, it never occurred the way you're insinuating it occurred.
Isn't it true, Mr. Galanter, that a more or just as likely scenario is that you represented him so that your involvement didn't come up?
Oh, sure. I said to him, listen, pay me $350,000.
572.
No, at the trial level, it was $350,000. I said, pay me $350,000 so we can conceal this from the world and you can protect me. That's insulting.
It may be insulting, however, a number of witnesses have testified under oath who didn't get $572,000 that you in fact had given Mr. Simpson this advice. As a matter of fact,
Who testified? How could that be? The
How?
only two
they get on the
males,
stand and they sit where you are. No,
there was nobody else
On
at the
some
dinner
procedure list.
but the people we've already described.
Now, right, and you were aware, of course, in the discovery that you got, and this would be, is this Exhibit B in this matter, that you were being investigated by the police concerning your involvement in this. Is that correct? Is it
I
correct?
think your characterization misquotes the facts. There were a number of rumors floating around. I had had conversations with Mr. Owens and Mr. Roger that the rumor that I was at the Palms was false, that the rumor that I was in an SUV was false. There was nothing to investigate because I didn't do anything. The only thing I did was I had dinner with my client and I told him to call the police. And if he couldn't call the police, call security. My knowledge of this event occurred during the phone call on the night of the 13th and when I visited Mr. Simpson at the Palms Hotel on the afternoon of the 14th.
As a matter of fact, the place where you were staying was searched by the police, correct? That's at Mr. Johnson's house.
I can't comment on that.
Sure you can. You got the discovery. You said you read all this stuff.
Let me see.
This is Exhibit B, page 8 of 10.
Exhibit B to this hearing. Okay. Just-
Again, the comment that threw, I knew that the police had gone to Junior's house, but the comment that threw me was they searched it, because my understanding was they just talked.
You stayed at Mr. Johnson's house, right?
I did.
Police came and searched it?
According to that, they did, yes.
Well, you were aware of this when you got the discovery.
No, I was actually aware of it when Junior told me about it.
Okay. Well, you're also aware of it concerning the fact that there was a police report written about it, right?
Yeah.
And as a matter of fact, they were talking about you renting a vehicle,
Yeah.
right? Now, the fact that you are mentioned in the police report, that the place that you were staying was searched, that you had had dinner the night before, dealing with, under whatever scenario you want, Mr. Simpson's retrieval of his property. Isn't it true that you should have told Mr. Simmons, OJ, my dear friend for all these years, I think that you should discuss this matter with another attorney?
To me, they were rumors. They weren't facts. There was nothing, I mean, they were just false rumors.
That dinner wasn't a rumor, was it? Was it? Was it?
Mr. Patero, as I
Was the
have
dinner a
stated-
rumor?
You don't need to answer that. Mr. Patel, just ask that question.
Did you ask Mr. Simpson, or did you tell him that given the nature of you being on the tapes, your names being mentioned on these tapes, the fact that Mr. Johnson's house had been searched, the fact that the police were investigating, and the fact you had dinner with him, and the fact you had conversations with him right before this incident, my question, sir, is did you tell Mr. Simpson that, Mr. Simpson, maybe you ought to run this by another attorney and get a second opinion?
What I
I'm
said,
going to object, Your Honor. Mr. Patero's question assumes facts that have been continuously denied by Mr. Glander, namely that he had some involvement in this whole thing, which he has stoutly denied all along. As Mr. Glander has stated, there is no basis for any claim of conflict.
Okay, Mr. Simon, let me just simplify the question. Did you ever tell Mr. Simpson that he should seek advice from another attorney?
OJ and I discussed the allegations of conflict. He laughed. And now, here's the other thing. is that when OJ was first arrested, you know, I was here. I had to go back to Florida and come back, like, and they turn around to do the bond hearing. When OJ and I got back to the house, I had thoroughly discussed with him, not so much because of the allegations of conflict, whether or not I should be his lawyer, and he insisted that I be the lawyer. Not only did I have trepidation about doing the trial, I also had trepidation about doing the appeal.
Thank you.
Do you have anything in writing outside of what you're saying, telling Mr. Simpson that you had trepidation about doing the trial and doing the appeal? You have anything at all besides you stating it now?
Mr. Patero,
Do you have anything, sir?
there is certainly nothing in writing.
All right.
The reason there's nothing in writing is because we talked or saw each other almost after this event.
So this fear of trepidation shows up no place in any sort of writing, right?
Listen, if any of the things that you're saying are accurate or true, why would Simpson have wanted me to be his lawyer? Why would Simpson have instructed his other lawyer, Skip, to pay me money? Why did we go through all this? Why did he get convicted? And instead of saying to me, you know, you jerk, you SOB, you led me down the primrose path, now I'm going to prison, why did he insist on hiring me to do the appeal?
Well,
I mean,
isn't
none
it
of what you're, Mr. Patero, none of what you're saying or implying is accurate, true, and it belies the record.
Isn't it true that Mr. Simpson would want you for his attorney because you kept telling him, OJ, it's okay to get your property back? Isn't it true that Mr. Simpson would want you for attorney because, as Mr. Grasso said, you kept telling him this is a piece of cake, there's no way they can convict you? Isn't it true that Mr. Simpson would probably want you for his appeal because you told Mr. Simpson that in fact this was it, you were going to win this appeal? Maybe those are pretty good reasons why this guy wanted you for an attorney. And maybe that decision
Object to
wasn't
the
so
compound
good
question.
because he's there now with you as his attorney.
Carl, you need to ask-
I'm done.
Okay, great. Objection sustained. Was Ms. Beverly going to ask any questions? Did you want her to go first?
I didn't have any questions. Your Honor.
Okay, great.
Mr. Glanter, if either the state or the defense had asked you to bring financial records here to show your expenditures in this case, would you have done so?
Yes.
You testified earlier that when you received a request from Ms. Palm for records, you called her and offered your cooperation.
Yes.
Did she get back to you after that and tell you what it was she needed?
I don't recall it was a get back. I think I called her and I think we spoke. I mean, I don't think it was a leave a message, call you back kind of thing.
Did she indicate to you what it was she needed?
There was something in the appendix that the Supreme Court Clerk's office had misplaced or destroyed. She wanted to know if I had it.
Did you?
No. Actually, that's not true. What I had, I didn't have the specific exhibit, but what I did email her was did I email it or put it on a thumb drive? I had on my computer, I don't want to misstate this, but I had on my computer what she was looking for, but it was not the exhibit that was filed. But it was the content of the exhibit, and I either emailed that to her or thumb drived it to her. Somehow I transmitted that information to her.
Did you spare any expense or withhold any services you had need of so you could pocket the money?
No,
Do you feel that you were adequately prepared for trial?
yes,
Was there anything that you needed to prepare for this trial that you did not get?
no,
As an experienced trial lawyer, do you always make objections whenever you have a legal cause to do so?
no,
And you're familiar, are you not, with Strickland versus Washington, which came out of the state of Florida?
yes,
And Strickland allows attorneys great latitude in making strategic decisions, doesn't it?
it does, it does.
And isn't it true that many lawyers handle the same situation differently?
That is correct.
Now, Mr. Patero asked you about the preliminary hearing, and he emphasized the fact that your client was bound over. Isn't it quite common for defendants to be bound over at a preliminary hearing?
Yes,
Aren't they bound over much more frequently than not?
this one was definitely getting bound over.
Are there other things a lawyer can do to benefit his client at a preliminary hearing besides winning outright?
The discovery that you get, the sworn testimony you get is invaluable. The
Right.
first look at the evidence is invaluable. Preliminary hearings are good things for defense lawyers.
Did you use your cross-examination at the preliminary hearing in this case to get discovery?
Yes,
Isn't it also useful as a device for pinning witnesses down to their testimony?
yes,
At some point during your representation, before the case went to the jury, did you discuss with Mr. Simpson what the potential penalties for the things he was charged with were?
yes,
Did you discuss that with him prior to the final discussion of a possible plea?
the penalties in the case were discussed often.
So would you have discussed them prior to the final discussion you had with the prosecution as to a possible plea?
Yes,
Was there ever an actual plea offer tendered in this case?
Well, actually, Judge, I think that's going to be the legal conclusion.
yeah,
Well, as a lawyer,
Well, without,
look,
I don't know what this almost plea offer is.
Can I-
Being
can I
pregnant, so I think it's calling for a conclusion, and I
Hold on a
don't know
second, Mr.
what it is he's,
Okay, the objection's overruled. Nancy, Mr. Williams.
okay, so I looked, what I consider to be a plea offer is, we're gonna drop X, Y, and Z. Your guy pleads guilty to count one. We're gonna recommend X. This is gonna be the range. Now, that never occurred. There were definitely, discussions, like feeling each other out as I've testified, and that occurred. But in what I do, I discuss those conversations with my clients anyway,
and you did in this case.
and I certainly did in this case.
It was brought out during the trial that there was no mention of guns in the tapes, wasn't it?
Correct.
Now, you've testified repeatedly that you did not advise Mr. Simpson that it was okay to go get his stuff back at the dinner of September 12th. Is that correct?
Correct.
Did you ever advise him in any of the phone calls you had with him that it would be okay to go get his stuff back?
I didn't know about this till the night at dinner, so the answer to that is no.
Do you know why it was that Detective Caldwell admitted your calls to and from Mr. Simpson from his chart?
I have, well, can't say I have no idea. I know that Judge Glass was concerned about confusing the jury. And I don't know if that went into Detective Caldwell's decision or not, or Mr. Owen's decision or not, and I just can't say. I really don't know.
Would you classify the stipulation that there were no calls as a legal fiction?
Yeah, I mean, you could call it a legal fiction. Yeah, you could call it a legal fiction.
In this case, it was a legal fiction that Judge Glass was fully aware of and approved, wasn't it?
Right, well, that's the whole issue. You know, as long as the court's aware of it, everybody knows what it is, everybody's discussing it.
Did you and I discuss several weeks ago you appearing here as a witness?
Yes.
And what did you tell me in that discussion? It was just between the two of us on the telephone?
Well,
Which-
I will object
Mr.
because
Simon, perhaps if you could point to
Yeah, I'm
a
not,
specific topic.
what were we discussing?
You were both talking, I couldn't understand what either
It's
one of
okay.
you.
If you could clarify what topic you were discussing maybe, so Mr. Belanger can ask.
I thought I did. If we
You said
discussed him coming here as a witness.
And that's it?
That's what I'm asking, if we discussed him coming here as a witness several weeks ago on the telephone.
Yes.
He said yes.
You requested that I come, I said, of course.
Did I mention the possibility that I might have to use the Uniform Extradition of Witnesses Act?
You did.
And what was your response to me?
You don't have to do that.
And I took you at your word, didn't I?
Well, I mean,
Well, I agreed with you, didn't I?
yeah, nobody knocked at my door in Florida to hand me a subpoena. But again, I considered it a privilege to practice here. I
Right.
consider myself an officer of the court. I was admitted pro hac vice. It was an honor to do it, even with all of this. And nobody would ever need to send marshals to my house to subpoena me, or
Right.
whatever a process.
And you came and saw me bright and early this morning and voluntarily accepted service of a subpoena, did you not?
Correct.
You're a gentleman and a man of your word.
Thank you.
Do you know if the police found...
yeah, you may want to reconsider that one.
No, I don't think so. Do you
I'm not
know if
commenting on it, it's just vouching, so I was
Okay.
just recording the comment.
do you know if the police found any stolen property when they searched Junior Johnson's house?
They didn't.
Do you know if the police ever found that you were renting a white Infiniti on September 13th?
They didn't.
I have nothing further, Your Honor.
Just ridiculous.
Okay. Anything else, Mr. Pataro?
Judge, I do want to, you have sent Mr. Simon at least one document based upon Mr. Grasso's testimony, correct?
That's correct.
And you did that by watching the media wherever you were?
No, that's incorrect.
Well, how did you know Mr. Grasso had testified?
Ken Ritter sent me an email.
Okay, and therefore you then sent Mr. Simon some documents?
Tuesday morning.
I'm just asking you, did you? It's, you know, people would like to
Yes.
just the answer, did you or didn't?
Yeah,
You know what,
absolutely.
Mr. Pataro, let me just ask, what, because Mr. Simon came in and made a representation that you had heard some media reports, so I would actually like to know just what it is that you have seen or heard since the hearing
Okay,
started on
so
Monday.
couple things. One is until I had my conversation with Mr. Simon Tuesday morning that the rule had been invoked, I didn't know the rule had been invoked.
Okay.
Having been a lawyer as long as I had been, I assumed that it was, and I watched no TV. I'm a Heat fan anyway, so I'm trying to watch basketball and sports, and most of the week I've been watching the Food Channel. So I didn't watch any TV. Tuesday
Does it
morning,
make the food change? Does it make the food
yeah,
change?
Tuesday morning, Ken had sent me a story that I opened. And when I saw that there was discussion there about Gabe not approving of the tapes, I sent Mr. Simon an email with an attachment of an email. And that was it. And then, I mean, that was it. And I wrote to him, you know, I'm not gonna even have any more emails, articles, TV, anything.
Was it a story that Mr. Ritter wrote?
Yes.
Thank you.
Okay.
Go ahead, Mr. Petaro, I'm sorry.
Okay.
I'm going to object to this line as being beyond the scope of redirect, Your Honor.
Well, they were my. You are absolutely allowed to object to questions that the judge
Can I
asked,
roll?
but my intention actually was to ask him that in the beginning because I had some concerns about it, so I'm going to overrule the objection.
I'm right, but you win, you're the judge.
But I'm sure that Mr. Petaro will only ask questions within the scope of
Absolutely.
redirect.
And the first question I'm going to ask within the scope of redirect was that you did not interview any of the witnesses that were endorsed by the state in this case, did you?
That is beyond the scope of redirect, Your Honor.
No, it isn't. You said he was adequately prepared for trial. Want me to ask it a different way?
No, well, no
Go
objection.
ahead.
Sorry.
So what's the question again?
Did you interview any of the witnesses endorsed by the state?
I
Wait.
did not.
Right. So your adequate preparation for trial did not encompass interviewing witnesses, and that's what you said. Your adequate preparation of trial did not encompass hiring any experts in the case concerning the one audibility of the tapes, correct?
First of all, we've gone over all this before, and my testimony is what my testimony is.
Mr. Lamb, someday you may be a judge, but right now you're a witness.
Again, we did not hire an expert on the audibility issue.
Okay. Not only did you hire an expert on the audibility issue, you did not hire anyone to listen to the tapes, of which there are transcription services, to fill in the gaps on any of these tapes that were prepared by the police, did you?
Correct.
Okay, that was part of what you've response was your adequate preparation. Now, in addition to your adequate preparation on this of no witnesses and no experts, well, let me rephrase that. Most attorneys, no, I won't say most, you would understand that one of the reasons the state is compelled to give discovery in a criminal case is so that the defense can go out and investigate those facts.
Correct.
And you didn't do that.
Well, I'm not sure how to answer that other than.
Yes
what
or no,
I've
you
already
can answer it.
testified
You either
to.
did or you didn't.
Listen, there was an investigator very early on. We had a ton of information on Alexander McClinton, Beardsley, and we used it. So I'm not, I mean, I've already testified to this, and
Okay, let me ask you this. Mr. Blanton, when you were a prosecutor, I guess in Florida, is that correct?
correct.
In the prosecutorial office, you had investigators, right?
We did.
And you had those investigators to assist the attorney in preparation for hearings, correct?
We had the investigators to be able to get us the information that we didn't already have.
And, well, isn't that sort of an interesting problem? That if you don't investigate, you don't know what you have until you've investigated, do you?
Well, I'm not sure I agree with that.
You wouldn't agree with that?
Sometimes you have a lot of information at your disposal, and we had a lot of information at our disposal here.
And in addition, you're aware, I take it, as a defense, I'm assuming you've hired investigators before.
I have.
I'm assuming you know that in federal cases, that if you can't afford an investigator, that they'll appoint one for you.
Money wasn't an issue.
Well, Mr. Grasso testified that you told him it was an issue.
Okay. Haven't we already gone over all this?
Well, are you aware that Mr. Grasso has testified to the fact that you told him money was an issue?
Again, I don't know what Mr. Grasso testified to.
This legal, your testimony, you said you haven't looked at any of the transcriptions of this or television programs about this.
I'm not sure I understand what you mean by
Well,
transcriptions.
you know that
but
some
what
of these proceedings have been televised. Is that correct?
I am certainly aware that they have been televised. And as I told the court, I haven't watched them.
The reason, if I could, listening to some of your testimony, it almost mirrors some of the state's witnesses. For example, when you said that the reason you knew that Mr. Simpson wasn't intoxicated was because you watched his gait, that you watched the way he spoke the words, those sort of things, that they just seem to mirror exactly what the state's witness had said.
Is that a question, Mr. Chairman?
Yes.
I can't comment on that because I don't know what you're talking about.
And in addition to this, the adequate preparation that you did, or didn't do, I guess, besides no investigation and no experts, how many witnesses did you subpoena for this trial?
I don't recall. I think it was 2.
And this attorney you were talking about, this Jones, wasn't he actually the one that called the defense witnesses?
I think so, but I'm not positive. I think we called, no, actually, I don't think that's correct. I think we called Mr. Beardsley, and Mr. Jones called Mr. Scotto.
Now, were you invited to Mr. Scotto's wedding?
No,
You knew Mr. Scotto?
I had met him through Mr. Simpson.
And the one thing I did want to clear up with, you were talking about the letter from Ms. Palm and then your telephone call. Do we have that? That is old.
The letters,
The letter that Trish sent to M? Okay. The question I have is that on redirect with your ability to cooperate or your determination to cooperate, you do admit that Ms. Palm, on March 1st, 2012, asked you for any notes, memorandum, defense interviews, investigation strategies, and documents. And
We already went through this.
I understand that, and they wanted to bring it up again.
They can bring it up again.
Well, I tell you what, why don't you look at M and see if she asked you for that stuff?
You've
Did
already-
she or didn't she?
Here, I'll let you know.
Thank you, Judge.
Okay. Just ask us.
And you didn't send her any, did you?
As I stated earlier in the day, I got the letter, I called Ms. Palm, she told me what she needed. I expressed to her if she needed anything else, just let me know.
You didn't send her any of those items I just enumerated, did you?
My testimony is the same.
Well, I don't, I want to know, did you, didn't you? I don't know
I've already
why.
testified that I didn't based
You
on my
didn't.
follow-up with her.
I've done it, Drew.
Very briefly, Your Honor.
Oh, no, Mr. Simon.
Am I excused?
You are excused, thank you, sir.
Thank you, Your Honor.
Oh, no more?
We're
Okay.
done. At least with the,
Thank you.
Mr. Lancer. Thank you, sir. Okay, we're gonna go ahead and take a break.
May we approach real quick?
I can still go, right?
Absolutely.